Adam, how do I know what I'm supposed to do when like how I properly pay my employees? And then what happens if I get that wrong?
So those are good questions, and I answer those questions just about every day. And the answer to the first question is really simple. Okay, under federal law, which applies to all 50 states in the United States, you as an employer have an obligation to number one, keep records on how you pay people, including if they keep time, they should be keeping time, especially if they're non-exempt, and I'll talk more about that in a second. How you pay them, how often, and those records need to be accurate and adequate. Okay, so record keeping is number one. Number two is you have to pay employees at least the minimum wage. Okay, and in certain states like Florida, our minimum wage goes up every September. Okay, so it's a weird time of the year. In certain states, it goes up on the first of the year. So you always have to pay employees at least the minimum wage for every hour that they work. Okay. Number three is if employees work overtime, and at a federal level, that means above 40 hours a week. In certain states like California and Colorado, there's state over or daily overtime. You have to pay employees time and a half if they work overtime. Those are the three basic rules: record keeping, minimum wage, and overtime. Yet there's so many companies that get this wrong. And that leads into your next question, which is what happens if you get this wrong? Uh, First and foremost, you can be sued by your employees. And when there's smoke, there's fire with something like this. If you get it wrong with one employee, you most likely got it wrong with others. So, what does that mean? It can turn into a collective or a class action lawsuit. So, you multiply essentially how much you owe one employee times the number of employees affected by your improper pay policy. Okay. Separately, you could be audited by the government. Okay. The U.S. Department of Labor has jurisdiction to investigate to see whether you're keeping records in place. They can do that whenever they want, essentially. But what actually happens is you have a disgruntled ex-employee who leaves and who calls the Department of Labor and says, this company hasn't been paying us right. And that will trigger an audit. And the Department of Labor has the right to assess unpaid wages on the organization times two, which is liquidated damages. So you can have a Department of Labor audit going on, finding an assessment of unpaid wages times two against your organization. So you have that, and you possibly have the IRS or a local Department of Revenue looking into whether you've properly characterized the worker as a W-2 versus 1099. We have another video about that, so I suggest you check that one out.
Right.
But you can have class or collective action lawsuit or Department of Labor audit. Can be very costly, time consuming, inconvenient. These investigators, they don't just show up like in advance. They don't tell you when they're going to come. They just come and they just start grilling you with questions. And I've seen it happen many times where an investigator catches an employer representative off guard and begins to take down essentially admissions from the company. But if you're watching this video and you ever get a Department of Labor investigator or any type of government investigator on your work site, don't say anything and call your lawyer first. Okay.